All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5215, United States of America versus China Telecom America Corporation, appellant. Ms. Coomer for the appellant, Mr. Ross for the appellate.
Good morning.
Hey, please support. My name is Rachel Cummer, and I would like to reserve 3 minutes for rebuttal. Your Honors, the District Court erred as a matter of law by failing to undertake the 50 USC Section 1806G analysis. That is, by failing to determine whether due process requires discovery or disclosure of the classified information that the District Court found was lawfully surveilled. The statutorily required inquiry is distinct from the analysis under Section 1806F regarding whether disclosure may be warranted to aid the District Court in its review of the legality of the FISA surveillance. The District Court conflated these analyses and should be reversed. CTA is in an extremely difficult position defending itself against a black box, and Congress addressed that concern with careful and detailed procedural requirements in the FISA statute to protect both aggrieved parties and the government's interest in classified information. Congress directed the District Court to engage in an important sequence of analyses, and with respect to 1806G, it failed to do so. In this FISA context, it is of paramount importance that the District Court turn square corners on procedure. Now, while the majority of the District Court's opinion below is redacted, such that I cannot comment upon it, the reference to Section 1806G is unredacted and reflects a clear error of law. Section 1806F addresses disclosure of classified information about a search to help the District Court evaluate the search's lawfulness. In contrast, 1806G addresses disclosure of the fruits of the search as required to protect the target's due process rights. These are completely different and entirely distinct analyses.
Our review, if this is properly before us at all, our review would be de novo. Right?
And that's our position, yes, sir.
So why the law is very clear, you're not entitled as a matter of due process to classified information that supports an executive action like this.
It is true that we are not entitled absolutely to classified information, and that's not what we're asking this court for. We are entitled to the statutorily required determination under 1806G whether due process requires disclosure and discovery. And the District Court did not engage in that statutorily required analysis.
Why can't we do it if it's
Your Honor, we think that you could do it. We think that the most appropriate action, given the congressional statute that Congress directed the District Court to make this determination in the first instance, would be to reverse and remand to have the District Court make that determination.
But you're acknowledging it's de novo review, right?
Yeah, yes, Your Honor, we are.
So it's something that means we can do it.
Absolutely, we think that you can, and we think that that would be in alignment with both actions by the 6th and 5th Circuits, where they haven't conducted a de novo review of the evidence before it. We think that you could do that here. And frankly, we would be fine if you did so. We think we are entitled to that review. If you do it in the first instance, fine. We think the best course probably is to reverse and remand because it's the type of decision that district courts usually make. And that's what the statute said. It directs the district court to make the decision, and they didn't. But then, of course, that would be subject to further review by you. You could do it in the first instance. And I think that's right. So we think the district court misunderstood CTA's request for a due process disclosure under 1806G as a due process attack on 1806F ex parte and in-camera review provision. But we simply don't challenge that. We do not challenge the FISA process as constitutionally infirm or seek to relitigate this court's holding in Belfield that FISA passes constitutional muster. We think that we are entitled, as Judge Katsas and Judge Edwards have referenced, to a determination with respect to whether due process requires disclosure. It may be that the evidence that is in the classified materials that I can't speak to because I haven't seen any of it could contain evidence that is helpful to my client's defense. It could contain exculpatory materials or certain other materials that due process would require to be disclosed. I simply don't know, and I ask that this court do that determination or reverse and remand to have the district court do it first. I think it's important that in referencing 1806G, the district court quoted this court's decision in Belfield, which doesn't address 1806G at all. And that Belfield is only relevant here because this court recognized in Belfield that a respondent's difficulties in mounting its defense without access to the relevant materials, and found that Congress was also aware of those difficulties, and that Congress had made a thoroughly reasonable attempt to balance the competing concerns of individual privacy and foreign intelligence. And that balancing includes 1806G's mandate that the district court determine whether due process requires discovery or disclosure, which it failed to do, which is why we asked this court reverse and remand. Yes, Your Honor.
Suppose we decide in the FCC case that we can uphold the license revocation without reference to any classified information. Does that moot out this case?
No, Your Honor, it does not. This is a separate and distinct appeal. So were this court...
Why does it matter?
It matters for the following reasons.
I mean, this is all about revocation of the license. You have a perfectly fair concern that that might rest on classified information, which you haven't seen. And my hypothetical is just taking that out of the case. So what difference does it make?
I understand. So were this court to determine either through its own review of the classified information or if the district court were to make that determination in the first instance, that there in fact were helpful, exculpatory, or other discovery that we were entitled to, CTA could use that information either in seeking to have the FCC reconsider its prior revocation, in defending or seeking other licenses, or I think crucially, in its defense with respect to other federal agencies that we know have access to the classified information that we don't have. So it could be that it's almost like an ongoing poison of the tree, right? Like we ought to be able to defend ourselves. If there's something in there we can use.
Suppose we conclude that the classified information is not exculpatory and that the inculpatory unclassified evidence in the FCC record is sufficient to uphold the revocation. Does that then moot out?
I don't think it moots it out. I think that they are just entirely separate issues. We think that you should review the revocation case, as my colleague will address, purely on the unclassified information, because that's what's in the final agency record before you, not without reference to the classified information, which the government has said supports their case, but that they didn't rely on it, right? So I think with respect to the next argument, that should be limited to the unclassified evidence. I don't think that impacts whether we are entitled to a correction of the legal error here, which is that the district court did not conduct the analysis that was required under the statute. And we are entitled to a determination whether due process requires the disclosure of, it could be exculpatory or evidence under this court's unit standard that might be helpful or otherwise. And so I don't think it should moot it out. We would still be able to use that evidence in our defense were it to exist. And, as this court said in Nickery, just because you may not anticipate that a petitioner could put on such evidence, you also can't assume that we can't. We're entitled to a review of the classified information and to determine whether due process requires that disclosure.
Well, if we make the determination that in our view, you do not have a viable claim under the due process principles, that is, what was done was legally permissible. And I'm not sure where is that leaving you. What is your argument?
But Judge Edwards, I think that's two separate issues.
I understand what you're saying.
Well, okay. So it leaves my argument in the following place. It may be that the determination that the FCC made with respect to the unclassified evidence in the final agency record leaves you in a position of affirming with respect to the revocation. I don't know. I can't speak to that particular issue. Here, we are still entitled to know whether the classified information would have provided us anything we could have said in our defense and whether we could use that information going forward. I think that that's a critical distinction. China Telecom Americas could still seek other licenses, we could still defend other licenses. We could still be subject to actions by other agencies like Commerce or other parts of the federal government, other federal agencies. If this classified record that was obtained through FISA surveillance contains information that would be helpful to our defense, we ought to be able, under the FISA statute, we are entitled to it.
Helpful to your defense with respect to what? The FCC case or some hypothetical case that's not before us and that we can't contemplate?
Well, the case that is before you is whether the district court appropriately complied with FISA.
I understand.
The second issue is whether the FCC's determination was appropriate on the agency record before it. In the FISA case, it really isn't contingent on how the information is going to be used. Congress directed the district court to make a determination of whether due process requires that disclosure. Here, we think that we are entitled to that determination based on either your review or the district court's review of the classified record.
The whole predicate of the 1806 action is that the government intends to use the information in a proceeding.
I think that
The proceeding here is the FCC revocation.
that was the government's predicate for filing their petition, and indeed was the notice that we received and why we then knew that CTA had been subject to surveillance. But that's not part of the 1806G requirement, Your Honor. We were entitled to a determination of whether due process required that disclosure, and we haven't received it. And with respect, we submit that we should be entitled to it. I will hold my last 3 minutes if that's fine.
So wait, I want to make sure I understand your bottom line. Separating the case and just taking the review of the district court's decision, which is what we're talking about.
Yes, sir.
What is the error in your mind that would cause us to reverse?
The district
Specifically.
The district court made no determination. The district court was required to conduct a two-part analysis. We understand that the district court conducted an 1806F analysis and did not believe that it was necessary to disclose to CTA.
Tell me what analysis you think is missing, because this is de novo review, remember. What analysis do you think results, the failure to engage in it, results in reversal?
There's no Matthews analysis. There's no Matthews analysis. There's no analysis in the district court's opinion with respect to whether due process required disclosure of the lawfully surveilled, the evidence that she found lawfully surveilled.
All of which we can do. And if we conclude that with respect to, those are two questions you've raised, we conclude that there's no problem there, then you have no viable claim.
I don't believe that it's that we have no viable claim, Your Honor.
You have a viable claim, you can't prevail.
We are comfortable that this court has the authority, given that it's de novo review, to review the classified evidence in the first instance, were it to choose to do so.
Right.
And to perform the 1806D analysis here. We think the better course is to reverse the district court.
I've heard that. I understand. I know you prefer to get a remand. I'm trying to ask you, I want to confirm that we can conclude that all is fine under G, having reviewed the record, right? Isn't that right?
If you review the record and determine that there is no disclosure warranted, then I think that's a determination you could make here in the first instance, given the standard of de novo review. Yes, frankly, we just want someone to do the analysis. We think it probably should be the district court, but
so if you got an opinion from us saying we've done the analysis, de novo, we've looked at everything there is to look at, and there is no viable claim here. They have a claim, but we're not upholding laws against them. That would be the end of it, right? We certainly can't anticipate possible uses in cases that are not before us. So all you're talking about is the due process, the failure of due process. The district court, I'm just trying to make sure I'm understanding what you're saying. Your alleged error is the district court didn't do a clean enough review of the record as required by G, and therefore it should go back to the district court. That's what you're saying. If we look at it de novo and say, no, it's there, then what? And they're not entitled to disclosure.
If this court determines under 1806G, in its own de novo review of the classified information, that due process does not require disclosure, then we would not be entitled to disclosure. I agree with that. We have also asked this court to review the district court's 18 determinations with respect to the vast majority of the opinion that is redacted. We just don't have that in our briefs. There's really nothing I can say about it. That's a secondary request that we have. But our primary argument is with respect to what we believe to be the clear area of law on 1806G.
Okay, thank you.
All right. Mr. Ross.
Thank you, Your Honors. May it please the court, Jason Ross of the United States. The district court properly determined that FISA surveillance at issue here was lawfully conducted, and no disclosure of classified information was necessary either to make that legality determination or to satisfy due process.
Before you get into the merits, can I just ask you about your appellate jurisdiction point?
Sure, Your Honor.
So I mean, there's an interesting question about whether the district court order would have been reviewable when that proceeding was concluded and the FCC proceeding was ongoing. But the FCC proceeding is done now, so you don't contest that we can reach the merits we can reach the merits of what the district court did through our review of the FCC order, correct?
That's correct, Judge Katsas.
Okay.
This court can review the legality of the surveillance on its own in the FCC revocation proceeding, but the court lacks jurisdiction in 215215, this particular case. The question is largely academic at this juncture. Because
that would just come up through the PFR of the FCC.
That's correct.
Okay.
And the text of the Foreign Intelligence Surveillance Act makes that clear, that only a certain specific discrete class of orders are final.
It does not make that clear. And no court of appeals has endorsed that view, not even the Ninth Circuit that you point to. That's just not correct. The end analysis of your argument is no review of the district court's determination is possible because of H. The statute just doesn't address it. What it does is to make it clear that certain kinds of actions adverse to the government are clearly reviewable. But the government's in a different position than the claimants. And there's no court of appeals that's brought to review. None. You read Judge Randolph's opinion in Barr, he starts assuming that review is possible. The Ninth Circuit, the Fifth Circuit, everyone assumes, even the Ninth Circuit Hamid assumes that at an appropriate time, of course, review is possible.
Yes, absolutely, Your Honor. My argument was much more modest, rather that it's not reviewable on an interlocutory appellate posture, as it is here, or as China Telecom appealed here. In response to Judge Katsas, the question is largely academic at this point because the same two cases are before the same panel.
Now, what I'm saying is something more. Your assumption that it's interlocutory is questionable, but it may not matter in this case.
It does not matter in this case. That's correct. And so the court need not reach that question. The FISA statute itself makes clear, though, that every time the government files an 1806 petition, it is in conjunction with another proceeding. And so any 1806 petition is necessarily tied to an underlying substantive determination. Normally, that's in a criminal proceeding, and it would be brought in the same district court. And the logical conclusion of China Telecom's position is that in this case, the court could exercise appellate jurisdiction in instances in which the proceedings are bifurcated, but not in a criminal proceeding. So were the same order entered in a district court proceeding, Your Honor, the statute is clear that there would not be immediate review on appeal, but only after a final judgment has been entered. And it would be anomalous to have a different result here. But absent additional questions about the court's appellate jurisdiction, as the record plainly demonstrates, the surveillance here was lawfully conducted, and there is no necessity to disclose classified information, either under 1806F or under 1806G. Due process did not require any particular disclosure of classified information, and indeed, the government is unaware of any other circumstance in which a district court has ordered disclosure under 1806G, except in Daoud, which the Seventh Circuit subsequently reversed. If there are no further questions, we urge the court to dismiss case 21-5215 for lack of appellate jurisdiction, or in the alternative, affirm.
All right. Thank you.
Thank you.
Ms. Kummer, why don't you take 1 minute?
Honors, the government is incorrect that this court lacks appellate jurisdiction in this FISA appeal. This court has jurisdiction both under 1291 as a final order and as a collateral order. And I think it's particularly important here that we look at the kind of relief that would be available in the distinct vehicle. If this court exercises the appellate jurisdiction that it has to review here, you have the ability to remand to the district court, which is what Congress, as we've discussed at length when I was first standing here, the Congress directed to make this determination in the first instance. When this court, because this is coming up from an administrative proceeding, if this court were to review the FISA issue in the merits case, you only have the ability to remand to the FCC, which can't speak to the FISA issue. So in that instance, I think you would have to do the determination by yourself here on a de novo basis because there's no one to remand to. I think that's quite different, and it's an important point for appellate jurisdiction reasons, and I think something that this court should clarify when issuing its opinion in this FISA.
Suppose the FCC, and then I'm not going to hold up any longer, suppose the FCC determination had not yet been made and it wasn't scheduled for argument before this court for, say, a month or two, and all you had was the appeal from the district court.
Frankly, we think that you have jurisdiction here in this case, similar to.
No, just take my hypothetical.
Yes, sir. I'm doing so. We think that in some ways the answer is the same because you have jurisdiction in this case, regardless of whether that case is currently up on appeal before this panel or in the Fourth Circuit where we could have sought appeal from that case, or whether it's still languishing in the administrative agency following the Supreme Court's opinion in Congress.
We would not know in my hypothetical whether the FCC was going to use any of the classified material because we don't have the opinion before us.
We'll still be able to make a determination whether the district court would still have been able to make a determination whether due process required that disclosure. And I think that really loops back to our prior discussion. It is always possible in an appeal from the FCC that there would be a split in the courts because China Telecom could have taken an appeal to this court or to the Fourth Circuit. And, it wouldn't be a tag-along order. That is another reason why this court should exercise jurisdiction and either make the determination here in the first instance under D or remand. All right. This court has no further questions. Thank you very much.
Thank you. All right.
This is the
Case number 21-1233, China Telecom Americas Corporation, petitioner versus Federal Communications Commission and United States of America. Mr. Blau for the petitioner, Mr. Novak for the respondent.
Mr. Blau, good morning.
May it please the court, Russell Blau for China Telecom Americas. I'd like to reserve 3 minutes for rebuttal. Since the FCC embarked some 4 decades ago on a policy of inviting open competition in providing domestic and international long-distance services, thousands of companies have obtained authorizations to provide those services and invested untold billions of dollars in facilities to use those authorizations. In today's case, the FCC has announced for the first time they could revoke any of those licenses at any time without even allowing the carrier to see all the evidence against it or to defend itself at a hearing. This violated both the agency's own consistent past practice and the requirements of the Due Process Clause. In effect, the agency gave no weight at all to the carriers' reliance interests, said that the carriers were not entitled to rely upon the continued access to those licenses. The FCC admitted that a substantial motivation for its action was the United States government's view of China as a hostile foreign power. When this kind of political animus underlies an agency action, the need for the agency to
Political animus? You don't think that's a supportable conclusion?
It's a policy conclusion, certainly. The government's certainly entitled to view a foreign country as hostile if it wants to.
And they explain that at length in this order.
Yes. And although the FCC cited various other reasons for revocation, they made it fairly clear that they thought that the fact that this company was owned by the Chinese government indirectly was by itself a sufficient reason for revocation. Contrary to many decades of precedent saying that they would revoke licenses for egregious misconduct. Now they say that no misconduct at all is necessary. We suggest that even if the due process clause permits some agency hearings to be conducted without an ALJ presiding, the circumstances of this case would create a heightened need for such a neutral adjudicator, because the FCC had already expressed its policy views that dictated the outcome. The FCC's argument essentially is that this is a straightforward substantial evidence case, suggesting that if they had some plausible basis for their decision, then it doesn't really matter how they reached that decision. But that ignores the agency's duty to follow its own rules, as well as the fundamental requirement of consistency in administrative law. An agency cannot cherry pick its procedures and standards case by case to suit its desired outcomes. That would create enormous and costly uncertainty for all the other regulated parties, since they would have no idea how they could expect to be treated if they ever get hauled. In the past, the FCC has always designated contested revocations for hearing under its Subpart B rules, which it now says don't apply. The only exception being where a carrier has defaulted or gone out of business, when, of course, there's no point in holding a hearing. The FCC's argument that this represents a mere handful of cases is disingenuous, because there is, in fact, no case of a contested revocation that was not designated for hearing, or this one.
What's the difference between the process you got and the process you wanted? You're talking about a hearing, but in this context, hearing can mean written submission. And you made two very robust written submissions. So is it just not getting the ALJ?
Under the FCC's rules, if they had conducted a hearing on written submissions, we would have had, first of all, the ALJ or some other presiding officer. Secondly, we would have had an opportunity for discovery. And third, we would have had the opportunity to argue under Matthews versus Eldridge that we were entitled to an oral hearing before rather than after the FCC had reached its decision.
What would you take discovery of?
Oh, yeah, I was going to ask you the same thing. What's the alleged injury? What discovery have you been denied?
The discovery would go to the
Classified material?
in part.
You're going circular there.
Well, in part, if the court found we were entitled to some disclosure of classified information, that would certainly be
all right,
a part
so
of it.
take that off the table.
But
What
that
else are you talking about? Let me just tell you why, and I think Judge Katz is alluding to the same thing. In agency proceedings, even if it's a paper proceeding, you're not foreclosed for asking for review of certain materials if you think they're relevant to the position you want to advance. What did you ask for and were denied?
We asked for a hearing because we understood.
No, come on, counsel. I'm talking in the context of discovery. Be serious. What did you ask for, and what did the FCC deny in terms of discovery, other than the classified material? Nothing.
We did not ask specifically.
Right. So that's an idle argument which carries no weight. What are your other claims then? Because paper hearings are not unknown and can be done in many cases. And your argument, it seems to be it was totally inappropriate here, and I'm trying to figure out why.
It was inappropriate because we believe Matthews versus Eldridge factors are satisfied and require an oral hearing. We think, first of all, that the interests at stake here are very significant, that the FCC discounted them improperly. Again, the reliance interests, not just China Telecom Americas, but all of the other telecom carriers in this open market who rely upon having these licenses and having some expectation as to when they might be revoked. Even the government admits that there's some reliance interest here, although they try to minimize it.
If the case had involved an ALJ, who would make the final factual determinations for the agency?
The agency itself would
Right.
review the ALJ's
The
decision.
FCC.
That's correct.
So, I mean, I'm missing what it is you are alleging to be injury. The FCC is going to make the factual determinations. They're going to make their own declarations on substantial evidence, on their legal motions. What did you miss? And you admit you were not denied any discovery. So what have you lost?
I believe that if we had an ALJ hearing and we had a factual record developed through an oral hearing, even if the FCC did make those factual determinations against us, as you suggested, at least this court would have a much more robust record on a review in order to be able to review that decision. If there's no other questions, I'll reserve the balance of my time.
All right, thank you. Mr. Novak.
Good morning, Your Honors. May it please the court. I'm Scott Novak for the government. The FCC reasonably determined that allowing these companies to retain their Section 214 authorizations would pose serious and unacceptable national security risks. The record shows that these companies have the potential motive to harm national security because they're owned and controlled by the Chinese government. The record shows these companies have the ability to harm national security through their access to U.S. telecommunications infrastructure and to U.S. customer records and communications. And the record shows that these companies have failed to be transparent and forthcoming in response to inquiries from the U.S. government. Now, as I read China Telecom's reply brief and the argument so far, they appear to have largely abandoned any independent challenge to the substance of the commission's decision. They appear to be focused almost entirely on the commission's process. But the process here was entirely lawful and was appropriately tailored to the issues the commission was considering. The Supreme Court, of course, tells us in Matthews that the ordinary principle is that something less than an evidentiary hearing is sufficient prior to adverse administrative action. And here the FCC provided the companies both with detailed notice of the legal and factual issues it would consider, and with multiple opportunities to offer any relevant evidence and to present any relevant arguments. And I think as the argument so far is established, neither China Telecom nor the other companies here today have ever clearly explained why the procedures here wouldn't allow them to meaningfully present their case. There was no need, for instance, for live witness testimony here. Turning to the statutory and administrative arguments with respect to procedure, China Telecom, of course, concedes in its brief that nothing in Section 214 itself or the Commission's implementing rules specifically requires a Subpart B hearing for Section 214 revocations. And that's unlike the radio licenses where such a hearing is specifically required. And I think the debate between the parties here about whether there was or wasn't some sort of a past policy actually winds up being a bit of a sideshow. The order says we don't think there was a past policy of requiring a Subpart B hearing in all Section 214 revocations. We think that was handled on a case-by-case basis, and the facts in those cases were very different. But the order explains that even if you disagree with us, an agency can change policy. It isn't bound by past policy forever. And here the commission said that if there was such an across-the-board policy in the past, we now see that it's unwise, especially in cases like this one involving unique national security considerations. And so the commission disavowed it. And that's entirely permissible. That's just like the Verizon case that we discussed in the brief at pages 45 to 46. If the court has any further questions on the commission's process or on China Telecom, I'm happy to address those. And if not, then I can rest and return after Pacific Networks argues.
All right.
Thank you, Your Honors.
Does Mr. Blau have any time left? Oh, yes, that's right, you do. That's right. Go ahead.
Thank you. As Mr. Novak said, the FCC believed that China Telecom Americas had failed to be transparent and forthcoming. And in fact, the gist of their findings, to the extent that they address China Telecom Americas conduct specifically, was that the company could not be trusted. And clearly that goes not just to what did China Telecom do or not do, but what was its intent and motivations. And that's why particularly we think that discovery and depositions would be particularly important in this case. And I would also suggest that the Supreme Court's decision in Department of Homeland Security versus the Regents of University of California undercuts their argument that they can simply disavow their past practice without ever acknowledging that it existed. The court made it fairly clear that the agency has to grapple with and give reasons for departing from past practice, not merely pretend that it never existed. There's no further questions.
Right, thank you.
Case number 22-1054, Pacific Networks Corp. and ComNet USA LLC petitioners versus Federal Communications Commission and United States of America. Mr. Wright for the petitioners, Mr. Novak for the respondents.
Mr. Wright, good morning.
May it please the court, I'm Christopher Wright representing Pacific Networks and ComNet. Those two companies do not pose national security threat under Team Telecom's 14-factor test, which was not applied to them, but was applied with respect to every other Chinese-owned entity so far. Under what test? I just didn't hear you. So Team Telecom has a 14-factor test, that was not applied in our case. And it is not possible to conclude that my clients pose a national security threat under that test. That's because prior to the revocation of their authorizations, their primary business was selling prepaid calling cards. Team Telecom's test sensibly focuses on domestic communications network, and you just can't use calling cards to harm networks. You can't, in fact, and the FCC did not so conclude. What's missing here is the analysis that you'll find at JA 59 to 69 of China Telecom, the order relating to the Team Telecom recommendation relating to them. Now, we agree that they should get a hearing, but it's just, in that case, Team Telecom the real national security experts explained at some length that you could misroute traffic from, and that Google and Facebook and Verizon traffic has been misrouted. There's allegations about great canon attacks on entities. None of that applies to us. Nobody has alleged anything.
That's one of the national security concerns, but the same group of national security experts tells us we should be worried about China having access to the customer records. And that the calling cards implicate that concern.
So, no, Team Telecom declined to make a recommendation when the FCC asked. Team Telecom has not endorsed this espionage, blackmail and espionage theory. The FCC completely disowned the Team Telecom test here, which we consider unreasoned decision-making, and instead went off on its own test, unlike, again, all of the other cases involving China. And it ultimately said, relying on an NBC News report rather than anything Team Telecom said, that you could use information like the phone numbers people call to blackmail them into spying for China.
You're right. They stopped short. They were less definitive than they could have been in the time they had. But there's a lot of concern in the submission that they made to the FCC about inherent national security risks attached to telecom companies owned or controlled by the Chinese government, and they have increased significantly in recent years. The environment has changed since the 214 authorizations.
So with respect to Team Telecom's letter here, the one thing we know is that 3 members of Team Telecom, which are Justice, Homeland Security, and Defense, instructed the Chief Counsel of NTIA to respond to the FCC's request by declining to make a recommendation. That's in the first paragraph. Then there's the next 8 pages are all cut and pasted from other orders. None of them explain how prepaid credit calling cards pose a national security threat. I suppose the Chief Counsel felt she had authority to cut and paste these things. But the only thing we know from the real national security experts is that they declined to make a recommendation. They have a test. The FCC didn't apply it. And again, what's missing is you'll look at factors 8 through 12. They're just not in that Team Telecom order. What's at pages 59 to 69 in China Telecom's appendix. But nothing like that in our case.
I hear you, but they are saying that there's a heightened risk involving China and telecommunications. And why can't the FCC take that premise and then build on it a little bit using their expertise about calling cards?
So, Your Honor, I would say they're subtracting from it, not building it, because they're just not applying the guts of the test. And they've come up with their own test.
They talk about risks from calling cards, which I assume is not completely unrelated.
The entire risk from calling cards is that somebody could figure out, and these are their own examples, that you have bad credit history or that you've been calling Alcoholics Anonymous or something like that, or that you're have a mistress. That's another of their examples. And then the blackmail. That's the FCC's analysis. It would have been easy for Team Telecom to say, we agree, if they agreed. They didn't do that. So that's what's really missing.
They didn't disagree, though, right?
Pardon?
They didn't disagree.
That they made no recommendation. I
mean, what you're describing, sure, it's a little bit speculative. We don't know for sure, but it sounds a little bit like what the U.S. government does every day in adjudicating security clearances.
Well,
they ask about all that kind of stuff.
Yeah, I'm sorry, but Team Telecom the test, again, I'm not saying it was correctly applied to anyone else, but it's a sensible test. Sort of, can you disrupt traffic? Can you get into other people's computers? That's just silly with respect to prepaid calling cards. That's why I think they didn't do it. You talked about them having a short amount of time. My goodness, if Team Telecom had said, geez, we'd like a little more time to answer your question, would the FCC have said no? Team Telecom sent another letter 6 months later. They could have said revoke their authorizations if they thought it was warranted. And actually, if I could pivot to talk about the procedural issue for a moment and address the questions that you and Judge Edward asked with respect from our client's perspective, what we want but didn't get, two things: a neutral adjudicator and an opportunity to cross-examine. They would have made a huge difference here. If we had an adjudicator who could not be transferred by the chair of the FCC, that adjudicator would have felt free to, conduct a really fair hearing in our view, and would have asked questions like, oh, come on, blackmail people and have them spy for China because they have poor credit history, or mistress. Do you have anything more than an NBC News report? And secondly,
this is the ALJ point.
Yeah, that's the ALJ part. It would have been hugely important to have an ALJ. And the same thing. The same ALJs that under Free Enterprise Fund might be unconstitutionally insulated from presidential control. A due process requires what Article 2 might prohibit. Well,
it's pretty tough.
An ALJ would be way different than a bureau chief at the FCC, who the chair can, send to the tariff provision, the tariff office if the chair wants. An ALJ can't be punished in that way. A neutral adjudicator would have made a huge difference, and they would have asked hard questions. And again, we didn't even get a paper explanation the way the other companies had, applying what we think is the proper test the FCC should have applied. And, it sure would have been great if some real national security expert had testified before a neutral adjudicator. And the neutral adjudicator, first of all, could have asked, unbiased questions, and we could have cross-examined, sort of, tell us how prepaid calling cards really pose any threat. Has anybody else ever thought that this blackmail and well, it isn't the calling cards per se. It's possible access to U.S. data on shared database. Isn't that what we're really talking about here? I'm sorry, Your Honor. It isn't the mere presence of the calling card. It's the possible access to data on shared database. Isn't that what we're talking about? Because of China's ultimate ownership interest and the access to data. Isn't that what we're talking about? If we don't dispute that any carrier learns information about things like the numbers that people call. What we don't have here is a real national security expert saying that. No, wait. Stay with my question. Don't we have the shared? What we do have is an assertion that, and I don't think it's refuted, that there is access to U.S. data on shared databases, and China is the ultimate owner here, just as in the other case, right? So there are obviously there are privacy interests of individuals involved here. No, wait. I really, you can add whatever you want. I just want to make sure I have this straight in my head. I don't see you contesting the assertion that there is access to U.S. data on shared databases, and China is ultimately the owner here, just as in the other cases, and that's the concern that's being expressed. They therefore have access by virtue of ownership. The data that the U.S. is asserting here, we don't want them to have access to it, right?
So
Is that wrong that they have access or not?
I think you're not fully understanding the limited amount of data there is. In order to
No, I'm not expressing any understanding one way or the other. I want you to know what's in my mind based on what I've heard from the other side and hear what your response is.
So
My understanding is their concern is, greatest concern in this case, because of the way the case has been played out, is the possibility of access to databases which they should not have access to.
So all telecom carriers have to keep records of what numbers are called in order to bill.
All carriers do not have China as the ultimate owner.
So a couple of points here, Your Honor. The FCC ultimately decided this on a national security basis,
Right.
and so unless you agree with their blackmail and espionage theory, which again no expert has endorsed, the fact that data.
Why do I have to go that far? You're avoiding my assertion on behalf of the government. I don't know whether it's right or wrong, but you're not even responding, which makes me suggest that you're not disagreeing. Their arguments, I thought, was, look, China has access, by virtue of their position with this company, China has access to U.S. data on shared databases, and we don't want that. That's their claim.
So I don't know that they're shared databases. They're the company's own databases, basically for billing. I don't disagree that the owner, and it would be great to tell them ALJ why this wouldn't happen, but could the owner of the company violate the law and do something like find out that caller has called Alcoholics Anonymous or can't pay their bill and therefore might be, have bad credit? Yes, that could happen. That's the FCC's theory.
No, I think their theory, we'll hear from them. I think their theory embraces more than what you're doing it self-servingly, and if I were in your position, I would too, but I think they're asserting more. The access to the databases, in their view, is not insignificant because China's in play and China's the owner. Now, you're not, just from my point, you're not giving me a healthy, robust answer that serves you well. I'm not sure I understand your answer.
Right. So let me try again. So again, Team Telecom's more sensible test would tie what the services are to ways of misrouting traffic or ways of conducting cyber attacks and getting data out of somebody else's database, trying to find out how a case is going to come out from this court. Nothing like that here. Nothing like that at all. Pacific Networks and ComNet have got caught up with, a lot of much larger companies with different service lines. And again, I think they ought to be able to argue before an ALJ as to why they don't present a problem, but we certainly do. And again, in addition to neutral ALJ, the second thing procedurally that's really important here and that would make a difference is to cross-examine a real national security expert.
I'm sorry, I didn't hear.
Cross-examine a real national security expert. And the FCC says, well, that's too big a burden. I don't think cross-examining, having one expert explain to an ALJ why they see a national security problem and allowing us to cross-examine them. That's all we really need.
All right. Thank you. Mr. Novak.
Good morning again, Your Honors. I think that any suggestion that the executive branch agencies here didn't support the FCC's actions is thoroughly belied by the record. And I would commend the court to simply read the executive branch filings here. I think it's clear they support the FCC's actions, and you'll find those in the joint appendix in this case at pages 109 to 121 and pages 265 to 267. And as I think Judge Katsas recognized, those recommendations explain that the executive branch agencies think the company's authorizations raised serious national security concerns that couldn't reasonably be mitigated. I think that it's also, I disagree with my friend's submission that the executive branch agencies have somehow purported to adopt some single overarching exclusive test for everything that might constitute a possible national security threat. I think, first of all, and I understand this is based on the recommendation China Telecom. I think if you take a look at that recommendation, first of all, it makes clear that the factors outlined there are illustrative, not exclusive or exhaustive. It says that the factors include but aren't limited to those that are listed. And factor 12, one of them referenced by Mr. Wright, is a catch-all for all other activities with potential national security implications. On top of that, I think even if you look just at the factors expressly discussed in the China Telecom recommendation, you'll see that the threats posed by the company's services here are covered. That recommendation discusses risks of communications intercepts, risks of covert monitoring, risks of economic espionage. Those are the same risks that were identified by the commission here in its revocation order.
There is a lot of concern expressed in these letters. The Team Telecom responses, no question about it. But they do have a level of generality to them. This is just about China and telecommunications. And there is this express reservation right up front that this response is not offered as a recommendation. These are factual questions, and we haven't had time to assess. So, and you have an argument on the other side that even if we accept all the general concerns about national security, these companies are selling products that don't really implicate them. So what are we to make of that?
Yes, so let me first take your comment about the express reservation at the start and then turn to the generality issue.
Sure.
In terms of the express reservation, I think that fairly read, what it says is that this isn't a formal recommendation under the process set forth under a particular executive order, but explains that's for two reasons. That's number one, because the executive agencies here were being asked to weigh in on a relatively short time period, and the process to do a formal comprehensive recommendation can be fairly cumbersome. And number two, unlike in the China Telecom case, where the executive branch agencies were asking the FCC to start a novel proceeding, here the FCC was already on the case. We had their recommendation in China Telecom. We had issued an institution order. The process was already underway. And I think that given the other pressing demands on national security officials, it wouldn't have been a prudent use of the government's limited time and resources to then go through and produce a more comprehensive recommendation when the process was already going and the FCC was on the case. So could we have gone back and said, we'd like a formal recommendation with all the T's crossed and the I's dotted? The FCC could have done so, but it wasn't required to do so. And I don't think it would have been prudent to do so.
The FCC is required to give support in the record, substantial evidence to support the revocation order. Right? So what you're saying now just isn't ringing true. They have to support their own order. Would it have been prudent? Sure, it would have been prudent. You did it in the other two cases. The other case, why wouldn't you do it here? Because I don't understand what is it, flipping the questions I was asking co-counsel, what is it that you're particularly concerned about? Can this be read to mean that anyone who has a connection with China and China has some kind of ownership interest poses a national security interest and you can revoke whatever license it is they're holding?
Your Honor, I'll say first.
They have a computer and you could use their computer in their business and maybe do mischief and China's the owner. Is that the test?
No, Your Honor. In each one of these instances, in each one of these orders, the FCC did a comprehensive company-specific and service-specific analysis of what the risks were. So I appreciate.
Well, but I think my colleague was at least alluding to the question I'm trying to raise even more explicitly. I can understand what you're arguing in the other case, because it's pretty clear. I don't know what you're arguing here. What is the potential risk? And what you said so far in 10 minutes hasn't filled that gap for me. And what's the concern?
The concern here is explained by the orders, and this touches on the FCC's communications expertise about calling cards and what they allow the companies to do, which is why this comes from the FCC, not the executive branch agencies.
Oh, come on, that's all fluff. Give me an answer in terms of what is the evidence. The other cases are clear what evidence you're relying on, the FCC is relying on. And here your answer is, well, we didn't have time to put it all together, so just trust us. We think this is worrisome. So the first thing that occurred to me when preparing this case is, well, does that mean that anytime a company has China has a large ownership interest in a company, they may have their license revoked? Is that the test? You know, maybe that's permissible. I don't know. But is that what you're saying here?
Your Honor, I want to make clear, I'm not saying that we, the FCC, didn't have time to put it together. I think we did. There's an extensive order here. The executive branch response here.
Okay, forget the executive branch. What is it you think is the compelling case that the FCC itself has presented to make it clear there is a serious national security risk, which is what they're relying on? Serious national security risk because what? What's the because?
Because telecommunications carriers, including in the calling card context, by virtue of their position and the service they're providing.
Can you limit it to the calling card? Yes. That's all this case is about. So let's start the because again.
Sure. So when you use these companies' calling card services, they know who you call, when you call them, how often you call them, how long you speak with them. They often also have your personal identifying information. So they often know who you are, where you live, often what your credit card number is, sometimes your credit history. And they can cross-reference all of this information with other data sources, with public records, with commercial databases, with hacked data, and in this instance, with any information collected by Chinese intelligence services. So I think if you take a look at page 5 of the executive branch response here, they talk about the Chinese government uses all available levers to steal sensitive US person data and trade secrets. I think the theory here is that the Chinese government has at every opportunity been vacuuming up any potentially sensitive information it can collect on US citizens and can combine that in ways that can be exploited by a foreign adversary. And I think you don't just have to take the FCC's word for it. Congress has recognized the dangers posed by these calling records in the congressional findings behind the Telephone Records and Privacy Protection Act of 2006. The executive branch agency filings here, I think, warn that the Chinese government could use these companies to conduct or increase economic espionage and collect intelligence against the United States. And other courts, like the Second Circuit decision we cite, have referred to the startling amount of information that telecommunications providers have access to. So, I think even if the court were to look at this, say, through the Youngstown framework, here you have all three branches of government warning there are real dangers with this sort of information falling into the wrong hands, especially in combination with other information that may be in the hands of a foreign intelligence service. And I think there's no basis here then to second guess the government's considered national security judgments in this context.
The problem is you don't have the other branches of the government weighing in as you did in the other case. It would be very compelling if you had that picture, and you're glossing over that. I mean, I want you to know I'm paying attention. You're glossing over that as if it's so. It isn't so. It's exactly what Judge Katsas said. They kind of gave it a, well, we didn't have enough time. And as a court that reviews administrative stuff all the time, our first instinct in that kind of a situation is to say, oh, we can get you more time. We'll send it back to you. Take all the time you want. Do what you should have done in the first place.
Your Honor, I want to resist that a little bit.
I would expect that you would. That doesn't surprise me.
So I think the executive branch agencies came to us and gave us what they have from their standpoint. and then the commission adds something, which the other agencies don't have, which is the communications lens of understanding what, by virtue of the services they provide, in particular these calling card services, the companies can do. Now, I suppose you could envision a three-step process where the commission then goes back to the agencies and says, hey, okay, taking what you told us earlier from your expertise, and now taking what we've told you from our expertise, can you, put those two together and button this up into a, comprehensive explanation where everything appears on one piece of paper from the other executive branch agencies, rather than us giving you something where everything is stapled together in the FCC's order here. Now, I don't think anything requires that extra process, and I do think it would be problematic, particularly the national security context, to add that sort of extra delay. There's always a risk during that time that malicious activities could take place. And I think also, given the number of other pressing concerns on the plate of national security officials, there'd be another risk that you're diverting the government's limited resources from other national security concerns to undertaking extra process here that isn't necessary in this context. So I think that what we've given you is sufficient. I think it's particularly sufficient given the national security gloss in this case.
Am I correct? You mentioned delay in the other case, China Telecom, that it took 19 months for the commission to issue the order.
Depends a little bit on what your measurement points are, Your Honor, but I think the easiest answer there is that, as is reflected in the first case argued this morning, the FCC had FISA information in front of it in that case and was awaiting the district court's ruling on the admissibility of that information. That came in, I believe, September of that year, and the commission adopted its order the following month in October and released it a few days later in November. So I don't think that there's any plausible suggestion here the commission or the government wasn't acting with appropriate dispatch in this context. And I will say finally to Judge Edwards' question, if the court does have any concerns that something further should have been done to button this up, to dot extra I's and cross extra T's, or maybe that's what we're talking about, dotting the J's and crossing the X's, I think at most that would call for a remand without vacature for the additional process. I do want to stress there would be significant national security dangers were there to be a remand in the interim that would allow some of these services to restart if this is simply a paperwork issue.
Right.
Thank you, Your Honor.
Does Mr. Wright have any time? All right, why don't you take a minute?
Thank you, Your Honor. Especially with respect to your questions, Judge Edwards, about the storage of data, I should have pointed out that, Team Telecom has overseen these companies since 2009 when they entered into a letter of assurance. If you look at JA 71 to 73, you'll see evidence of lots of back and forth between Team Telecom and the companies. And specifically, Team Telecom has known about the data practices and hasn't objected. The companies have offered, to the FCC, tell us what you want as mitigation for us to do with the records, and we'll do it. But the FCC sort of shifts position and doesn't have an answer here. If the companies would do what they said, if it's at all reasonable, I'm sure. I hope the court will vacate the order if the court, so the companies, our stay was denied, so the companies have ceased providing these services. So if you remand, I would, without vacating, I would ask that, as in many other cases, you ask the FCC to act within 90 days or 6 months, or you'll vacate the order because there'd be a real danger of just sitting on it. Thank you.